Hello guys and good this time to you and welcome to another version of this tutorial legal method, a course designed by Bentes Tolapia at Northeastern University, Gombe, Faculty of Law. So in this week 4, we are going to look at substantive and procedural law. Just like you knew in your previous class, we have discussed the classification of law. So this is also a classification of law. It's going to go based on the laws that set the rules and the right, wrong, the rules, the principles, and the laws that give you if your right has been infringed, what are the procedures to follow. So let's go straight into notes. Just like I'm going to be straightforward and hitting on the head. So introduction. The distinction between substantive and procedural law lies at the heart of legal system worldwide. Like worldwide, there is a distinction. In these lectures, we will explore the concept of substantive and procedural law, as well as the distinctions between written and unwritten law, customary law, Islamic law, and various global legal traditions into common law, civil law, Roman, etc. So just it's more of a repetition of the previous lectures we have treated. So the first thing is substantive law. Distinction and characteristics. Substantive law defines the rights, duty, and obligations of individuals and entity. That's what substantive law does. It tells you what are right, what are wrong, what are your duties. Okay? It governs the substance or content of legal rights. Like that's what substantive law does. It governs the substance or content of legal rights, and liability addresses matters such as property, etc. That's substantive law. Example and illustration. Example of substantive law include statute. Statute are judicial and legislative enactment. Those laws made by legislation, they are called statute. Statute regulations and judicial decisions that establish legal rules and principles governing various aspects of human conduct. These are substantive law and social interaction. Substantive law provide foundation for legal rights and responsibilities, etc. That's all about substantive law. And first, because we have treated this thing earlier. So what is procedural law? Procedural, they are laws that led the procedures. Like they said, if your substantive law has been infringed, these are the way you can follow to get justice. Okay. So nature and function. Procedural law sets forth rules and procedure for adjudication, adjudicating legal dispute and enforcing substantive rights. So if you want to adjudicate, adjudication means to go to court, adjudicate, to seek for justice. That's what is the meaning of adjudication. Okay, you can jot that down. It governs the process by which legal claims are brought, litigated, and addressed in court or other dispute resolution forum. This is the resolution. I cannot move this image of mine, that's why it's here. So this is procedural law. It tells you how you can go to court, what are the procedures to follow. There are differences between criminal procedure and civil procedure, okay? So that's about that. Example and application. Example of procedural law include rules of evidence. That's what are the rules to bring an evidence. If you just bring evidence anyhow, it will be struck out. Court procedures, how will you appear in the court? What are ways you can move motion in the court? And the rules of civil and criminal procedure that govern the conduct of legal proceedings. Procedural law ensures the fair, efficient administration of justice, protects procedural rights involved in in legal dispute. So that's what procedural law does. So another one is written and unwritten law. So we have done it previously. What are written law? The ones that are written in codified. I told you the meaning of codified means something that is written down in a section or something like that. Then unwritten law, the ones that are not, such as the customary law, etc. So written law refers to the legal rules and principles that are codified in statutes. Statutes, I said they are legislative enactment, right? So constitution, regulation, and other formal legal instruments. That's what is written law. It characterized by its explicit codified nature, like they are written, providing clear, accessible rules for governing etc. They are unwritten. Unwritten law, also known as common law or customary law, like just like I told you, unwritten law are not they are not found. Like common law system, like I told you, there is no any codified system that says this is the exact common law. Common law is based on judicial precedent, okay? And also customary law, no any rules of Hausa or rules of Igbo language, no. All the laws are unwritten, so they are found in the minds of the people who are in the tribe or something like that, okay? And the principles that are derived from custom, judicial decision, and other legal tradition. It is characterized by its flexible and evolving nature, which legal rules with legal rules and principles being developed in a refined etc. This is just about it. Customary law and Islamic law. What is different between customary law and Islamic law? So this one we have also treated it. Customary law is a body of unwritten legal norms. This is the definition of customary law. They are body of unwritten legal norms and practices that govern the conduct of individuals and communities based on standing tradition and custom. So these are unwritten laws that governs the behavior of people or individuals or community based on the long-standing traditions and custom. Their tradition has been standing for long. It is prevalent many so it is prevalent in many societies, practiced in rural and indigenous community, often consist with formal legal system, etc. So Islamic law or Sharia law is a comprehensive legal system derived from Quran and the Hadith. That Hadith is the saying and action of the Prophet Muhammad. It is supposed to be Sallallahu here, and legal scholar. It governs various aspects of personal and communal life, including family, heritage, etc. That's about Islamic law. Global legal tradition. Global legal tradition. A common law. Common law is a legal system based on judicial precedent and case laws, where decision of higher court serve as binding authority in subsequent cases. Like if a higher court make decision, it serves as binding in subsequent cases that are yet to come. It is predominant in English speaking countries such as United Kingdom, United States, Canada, etc., Australia, etc. So that's about common law. Then civil law is a legal system based on codified statute and legal code, where laws are enacted by legislative body and applied by courts. It is prevalent in continental Europe, Latin America, and part of Africa and Asia. Countries such as France, Germany, Japan follow civil law, just like I told you earlier. Then Roman Dutch law. Roman Dutch law is a legal system derived from the Roman and Dutch legal tradition, which has influenced legal system in countries such as South Africa, Sri Lanka, and Indonesia. It combines elements of Roman Dutch law and local custom law and focus on written law and legal system, etc. So Chinese law. Chinese law is a legal system based on a combination of statutory law, administrative regulation, and judicial interpretation, influenced by Confucian philosophy and social principles. So that's about it. Focus on moral principles. It governs various aspects of economic, social, and political lives of the people, etc. Then what is customary law? Again, we have discussed customary law. Are legal based on tradition, norms, practice, and we have discussed this one. Then comparative analysis of the study. Analysis, the analyze the int. This one a question. Analyze the interplay between written and unwritten law in Nigerian jurisdiction. With example, this is a question. Foreign comparative analysis. Compare and contrast. This is a question also. conclusion. So we are done with this note. Follow us on the next where we are going to look at week 5.